Prashanthi Reddy Garu to discuss the latest updates on immigration, the new HR 1044 and S386 bills that are in discussion, followed by the Q&A session. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. We'll start taking calls in a few minutes. Before that, I would like to repeat the disclaimer. Please note this show does not provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV news or agents are not responsible in any way for your actions. Please use the information at your own risk. Hi Prashanthi Garu, how are you doing?
Hello Ranjit, I'm good, thank you. How are you?
I'm good. Thanks for asking. So yeah, we have a few immigration updates from the last week. One of the, I think, good news is DACA has been reinstated, followed by HR 1044 and S386 bills being moved in Senate and Congress and being part of the discussion. Could you please throw some light on the updates and then we can look further into each section?
Sure. So as you said, yes, you're right, DACA has been reinstated, and so it's been reinstated in full force pretty much. So as it was pre-Trump era, it's been, it's for the dreamers, basically, DACA. So anyone who entered into US and went to high school here and for example, they are being given preference because, even if they went out
Q&A session has started.
It is not because of their inaction, because of their parents' inaction most of the time. So, it didn't seem fair to punish them for something that their parents did or did not do. So they are basically giving a path. It's not really, it's a temporary respite, DACA really. There's no path to citizenship or green card right now. But you get a temporary status whereby you get a work authorization, and then of course you don't get, so you're able to go to school. A lot of these young people, want to go to college, and so, that this will help them, and also, to get jobs. So they'll get a temporary EAD, which they can keep renewing. And there's discussion, further discussion on how to further, move forward with DACA and give some final conclusion for these people so that they can finally attain a green card by, meeting some preconditions. So that's DACA for you, and it's reinstated. So it's good for everyone. All those people who came here under the age of 30, who went to high school, there are a lot of requirements, so you should go through them. And if you're one of those people, if you're out of status, you can apply for DACA. During the Trump time, it had, basically they had rescinded it, and then it went to court, and then the court has now ordered that it be put back. So that because the law, it was unconstitutional to rescind DACA. So now the more important thing that we were discussing on our agenda today is the S386 bill in the Senate, which is the Fairness for High Skilled Immigrant Act. So recently, I think last Wednesday while we were on the show, in fact, they passed it in the Senate. And at that point, we did not have all the details of what, the bill entails. So yes, now we have all the details. So just to step back for a moment, this Fairness for High Skilled Immigrant Act, these bills have been passed in the House already, and now it's been passed in the Senate. And this is basically for those people who basically Indian and Chinese nationals, because they are the ones that are backlogged. The employment-based EB2 and EB3 category people who have been backlogged because there's a high demand among Indian nationals, and every country gets only 7% of the total green cards. So there's it's country-based, and which is completely unfair because number one, every country has a different population, right? You can't compare Iceland to China. So it doesn't seem right to give a certain percentage to a certain population which has, billions of people, and certain percentage to another country which has, very few people. So it was inherently unfair to give it based just on countries. And also what was happening then is that the demand for Indian nationals was so high that they would be in the country. They would, from the last 10 years, 15 years, people have been in the country, and they've been waiting to get their green cards. And meanwhile, thousands of people from other countries just come in, wait for a few years, or sometimes they don't even have to wait, and they immediately get their green card. So that seemed unfair also in the face of it. And also, if you see all these people who are waiting, they're all high-skilled people and getting salaries of over 80,000, 85,000, so they're highly paid people, they're high-skilled people, and they're mostly working in occupations where there's a shortage in the technology field. So considering all this, there has been a lot of push or activism to advocacy to do something for this section of people who have been stuck in a limbo without being able to get a green card and having to continue to renew their H1 status. And on the other hand, the H1 status is getting more and more difficult to renew and stay on because there are so many restrictions that are being added to the H1B category. So in so many instances, we have seen people have actually left the country because their children are aging out or have aged out. And so, nobody wants to stay in the country unless their children can. So it's a question of family unity. So we've seen a lot of people leave over the years. So that's a big negative for the US economy because all these people are high-skilled people. And all those jobs really have just gone abroad. So nobody benefits with it by not, finding a solution to this problem. So they are attempting to find a solution right now. The Senate already passed the bill with a massive, the House previously passed a bill with a massive vote of 365 to 65, almost unanimous vote. And the bill basically says that the country quota should be removed, which means that the 7%, every country getting only 7% of the green card allotment should be removed, and it should be based on first come, first serve, and based on merit. This is for the EB2 and EB3 category because those are the categories that are backlogged. So the Senate bill has done that, and there are certain, again, several elements to it. But today we're going to talk about the House has done that. There are certain elements to it. Today we're going to talk about the Senate bill because it was passed recently. Now the Senate bill basically, again, went through an entire history of events. There were many Republican senators who made objections, made amendments. Mike Lee was the one, I think, who spearheaded to pass the bill with a unanimous consent. And there were many objections from Chuck Grassley, Rand Paul, David Perdue, Dick Dublin, and then recently Rick Scott held up the bill, and he put in some of his some amendments, and we will talk about that a little later. But they put in Rick Scott's amendments, and he has basically withdrawn his objections, and the bill was able to pass last Wednesday. Now this bill, it's not done yet, folks, because first of all, the Senate bill and the House bill are very different. So this has to go back to the House and go back to the Judiciary Committee and has to be voted on again. And of course, those differences have to be resolved. Basically, the House Judiciary Committee has said that they have already voiced opposition. The Democrats in the House have voiced opposition to some of the some things that are in the Senate bill. So we will talk about that again. And so they may not agree with some of these amendments that were made in the Senate bill. But hopefully they'll be able to find common ground and it will be resolved. The flash update is the House has extended its session until December 18th. So there's more time now to actually look into this because most importantly, the bill will die if it's not approved by January 5th. And that is not, we have the December holidays coming up, and then in the first week of January, nothing's going to happen. So whatever has to happen by December 18th. Otherwise, everything is back to square one. And it's a long road that we have traversed. So hopefully there will be an ending and we don't have to start again, at the beginning. So the two
Prashanti
sections.
Garu,
Yes.
before we get into sections, we have few callers. Let's take the
Okay.
call, and
Sure.
then there are 3 callers. Hi, I think Manoj, number ending with 2474.
Manoj.
You are on the air.
Yes,
Please
Manoj.
go ahead.
Hi, thank you for taking my call. Can you hear me?
Yes.
Please go ahead.
Yeah. So hi, Prashanti. So
Hi.
actually, I have traveled to India in month of March 2020, and I got stuck here due to the embassy closes. And last week, finally, I got my emergency appointment approved, and my H-1B visa was issued actually. So I'm planning to travel to United States next week, but on my H-1B visa stamp, there is no annotation saying that I am like exempted from proclamation, like national interest exception. Many people who went to visa along with me, they all got annotation saying that NIE exempted from proclamation some number. But I don't have that annotation on my H-1B visa, but my H-1B visa is valid for 2 more years. So can I travel, or there will be any problem at the point of entry because there is no annotation on my H-1B visa?
You should be able to travel, and I think the reason that there's no annotation is because of the court case. The courts basically held that Trump's executive order was unconstitutional, right? So it could be because of that they have not really found the need to annotate it. You have gotten an emergency visa simply because of closing, because the consulates were closed. But for an emergency visa approval, you don't need an annotation.
Okay, because we went 5 people together actually. 5 people went together with the same window, and all the 4 people and 10 people who got visa stamped on the same day, the 9 people got this annotation except me. And also after me, there are some people, my friends went like 5th, 6th, and even today they went, and even they all getting these annotations actually in my. But I'm the only one in like 500 people who don't have this annotation. I'm just wondering, will this be any problem, or I can just travel and I can expect the port of entry? That's what I'm confused.
Well, the fact that you were given a visa itself means that obviously you qualify, otherwise you won't get a visa. So even if they have to do something, they will.
Yes.
They will basically. What they're going to do is they will contact the consulate if they need to. The only thing with this annotation, what happens is the consulate is contacted, the port of entry is contacted in advance. So the consulate sends emails to the port of entry with reference to all the people who have been given this emergency visa, the exception to the, who qualify under the exceptions. And so it was easier at the port of entry for, they didn't have to do any further verification. But if the annotation is not there, it's possible that they will be some extra processing. But that's not something that you need to be worried about. But, one thing you could do is send an email to the consulate. You may not have enough time.
Yeah, and other thing is, the proclamation anyways is going to expire on December 31st. So if you just want to be on the safer side, just plan trip after 2 or 3 weeks, that's another way.
Unless it's extended, Ranjit, because Trump might extend it because he's still in power.
Yeah, only until January 19th. So
yes, so then you would have to just travel after January. Because once the new government comes in also, we don't know whether they'll immediately, what they'll do. So my suggestion is, send an email. You should have sent an email to the consulate if you had any issues.
Yeah, I sent an email. I sent an email. They said that, I have to submit my passport for correction. But my flight is like next on Wednesday, coming Wednesday. If I submit my passport for correction, I don't know like how long they will take. And my employer want me to come in this month itself. The last is the last date my employer gave to me. So I'm just worried, like, if I submit a passport, I don't know when I'll get my back passport after the correction happened. If I travel like this, so do I need to, worry about the port of entry, things like that? So I'm in dilemma actually. If I want to submit the passport, I can just go with the same visa.
Well, if you have a work situation and if you have to come in, then I would say because it's not a mistake that you have made, I would go ahead and
Yes.
try to come in. And if there is some issue, then you can get it corrected, and you will have to again fly back.
Got it. Yeah. Thank you so much, Prashant. Thank you so much.
You're welcome.
Okay, we have another caller, number ending 5393. Number ending 5393.
Hi, this is Senthil from Dallas, Texas. Hi, Prashanti.
Hi.
I'm with like a H-1B visa which got exhausted on 3rd week of October. So I have completed my 6 years quota on October 3rd, 3rd week of October. So my employer applied the PERM on June 1st, and last week only it got approved. So meantime, since I want to maintain the legal status, I just applied the B2 visa for me and for my family to stay in the USA.
Okay.
So meanwhile, my perm got approved, and they are going to file the I-140 in a couple of days. So my question here is, since this is a new scenario because of COVID, we had some hesitation. That is why we didn't opt to travel to India and then come back to once everything gets approved. We stayed here just by applying the B2 visa. Will it make any impact in while applying the getting the extension?
Extension for your H1, you mean?
Yeah. Now I am with B2 visa. My
So
my
change
spouse
of
and
status.
kids, everyone is
So
in
it's
B2.
not an extension, it's basically a change of status from a B2 to H1. So once your I-140 gets approved, you can file for that change of status. By then you may not get the B2, but based on the receipt, you can file for change of status. A lot of people are doing that, and that's the only, other than leaving the country, which again is not advisable nowadays with COVID, a lot of people are doing what you have done. So, I don't see, there can be an issue with any case, but I don't see a particular issue with your case because a lot of people are doing it.
Okay, so they will. It's going to be completely like a exemption cap kind of thing, or they will provide the 3 years validity for the new H1.
So they will give 3 years because it's based on an I-140 approval.
Oh, okay. So how long for the H1, H4 processing time will take? Because mine is going to, they are applying on premium. For H4, how much time it will take generally?
There's no premium for H4, and nowadays they're not processing H4s as all, along with H1s. They're not necessarily sometimes. I mean, they used to before as a matter of practice, but now they are not necessarily doing that. So a H4 could take longer, especially if biometrics are needed. We can't say how long, but it's not. It was taking 8 months earlier, but now I believe it's taking about 4 months, 5 months. But it's not taking as much as it used to take. It's a little better now.
So in this case, like, so I'm going to apply a change of status, which will convert once I get approved, like H1 gets approved, I can switch from B2 to H1. What about the H4? Like since they are already in B2, till it gets approved, they will be in the same B2 status, or once?
No, they will be in pending. They will be in pending H4 status.
Okay.
Because they will file a change of status along with you. Yes, both of you will file together.
Okay.
And they will be in pending status. So the status is not at risk. They can stay. But if there's an EAD or something required, then obviously they can't work. But staying is not a problem.
So they will treat it as a H4, right? Because since it will take more for 4 to 5 months, even in the processing time, we can consider they are in the H4, right?
Yes, that's correct.
Okay. Finally, one question, Prashanti. Like recently, I switched from one employer to a new employer. They filed the amendment, it got approved, and everything goes well. Like now, for the extension, they are asking $1,900. Is it something just for a normal extension processing fee? Is it something?
Who is that? Your employer is asking you to pay?
Yeah. They're telling like if you are switching for a new employer for the first extension, the extension fee is 1,900.
No, but first
Apart
thing
from
is
premium.
they cannot take any fee from you.
Okay.
The employer is not supposed to take the fee from you for the H1 filing fee. They have to pay it themselves.
Oh, okay. Only premium we need to get it from.
Premium
from
is USCIS is a little lapse with that, meaning that they, still you can't pay your check. The employer has to pay, but they may not frown upon it as much. But that 1,500 fee that has to be paid, that by law has to be paid by the employer. The premium processing, if the employee pays, and if there's an audit, they will question it. But it's not completely banned. It's a gray area. But definitely the $1,500 has to be paid by the employer.
No, what about the filing fee for the normal cases for H1B?
And that's what I'm telling you. There's a 1,500 part of the fee is the 1,500 fee, which is used. I forget what the fee is called, but it is used basically for to prevent fraud. All your FTNS visits, they are able to fund them with that fee. So that fee, the employee is not allowed to pay. By law, employer has to pay. In addition to that, there's some other fees. There's the USCIS fee also. And that also, I've not had the benefit, they don't accept a check from the beneficiary. So all in all, it is worrisome that the employer is asking you to pay for the H1B process.
Okay, only on top of that 1,500, the USCIS filing fee only we need to bear, right?
You don't need to bear anything. Employer is supposed to bear everything for the H1.
Oh, okay.
Okay.
Okay, sure. So the final, sorry about it, like, so since we have the mess up over here, right, like, so we apply for a B2 and then we need to apply for a change of status again for H1. Will it make an impact when I'm going for stamping to India?
No, it shouldn't, as long as you've maintained your status.
Okay, sure.
Okay, thank you.
Yeah, thank you, Prashanti. Thank you so much.
Okay, we have a few more callers. Okay, let's take the next caller.
Sure, but just before that, Ranjit, that the previous caller that we had, there is an injunction on that travel order, on that travel ban, the non-immigrant visa travel ban. Federal court in California, U.S. District Court for the Northern District of California, on October 1st granted a preliminary injunction, which means they cannot enforce that ban. So he shouldn't worry about no annotation, because they're not enforcing that ban while this case is in process. So that's something to keep in mind.
The next caller, the number ending 7928. Hello. Yes, please go ahead.
Hi, this is Madhu. Actually, hi Prashanti.
Hello.
I'm having a history from. Hello. Actually, I'm staying in US from about 11 years onwards here. So over the years, I'm paying the complete taxes and everything continuous job and everything. So the recently one bad incident happened in 2019 is I got one DUI, which is completely isolated. But recently I heard that for the I-485 adjustment of status, there is a new policy memo changes, which will consider, earlier they would not see any criminal history or any moral conduct for the adjustment of status. But recently they start seeing with the new policy changes. So, but when it comes to my specific case, this is non-criminal case, but which is the DUI. So how much impact it would be there for the adjustment of status? But there is no serious aggravative factors on it.
Well, first thing is, it's not new. DUI by itself has never been an issue unless it's a criminal case, which means you were DUI and then you hurt someone, or you were so rash and negligent that you could have hurt someone, and they book a criminal case against you and they arrest you. That is an issue. A plain DUI could be a CIMT, crime against moral turpitude, but again, it's not really a crime. So if you have not been arrested or booked for a crime and you've been given a ticket or something for a DUI, then I don't see it as an issue.
I have been arrested for it. Yeah.
Okay, so it is a criminal charge
I got
then.
arrested for it.
Yeah, but you said it wasn't a criminal charge. Then how can you be arrested for it?
No, it wasn't criminal charge. No,
if it's not a criminal charge, then you cannot be arrested.
Disposition.
Sorry?
Oh, okay. But in the court disposition documents and everything, it is mentioned it is non-criminal case. It's a municipal violation. It's not even misdemeanor.
Okay, so if it's a violation, then you have to, well, maybe they arrested you and charged you with the criminal case. So the charging must have been criminal, but maybe the decision given by the judge, he brought it down to a violation, and so not a misdemeanor. Also, I don't see it as an issue. You have to disclose everything, of course. You have to disclose your arrest when you're filing.
Yeah, I disclosed everything.
No, I don't see it as an issue.
Yeah. Oh, okay. But is it anything? And there is another point they mentioned that the family ties with the US will be helpful. So it's like how we can prove that the family ties with the US. It's like I have one son born in US and have mother, sister, and everybody is here and they're citizens.
That's good for you.
So
you
it's like, is there any statements should provide it?
Well, first of all, I just finished telling you that it is not an issue. When it becomes an issue, then you can figure out all that. I just finished telling you that it is not an issue because it's not even a misdemeanor. It's a violation. Right?
Okay.
So you have to disclose everything.
Yeah.
You most probably will have an interview. You have to explain everything, what happened in the interview. You have to tell them it is a one-time charge. If they want, they can ask for affidavits from your neighbors, friends, relatives, showing your moral conduct, conduct, and that you're a good citizen, etc., etc. So that is the usual process. You're not going to have to file a waiver where you have to show ties in the United States. That's a waiver. That is if you commit a felony, not even a misdemeanor.
Also,
even for a misdemeanor, there's an exception.
Also, I believe in the state of New Jersey, just in the state of New Jersey, DUI is not a criminal offense. I'm not sure about the other states, but I believe in New Jersey, it's not a criminal offense, a DUI.
It depends, Ranjit. If you have a DUI and then you cause some physical harm to someone, then it becomes a felony. So it really depends on what harm has been caused as a result of the DUI. By itself, a DUI may not, it's a violation in most states.
Yeah. Maybe as you said, maybe if damaging the property or
somebody's property. If you plow your car into somebody's house or something, they might say it's a criminal offense because
there is no harm happened. Yeah.
No, we are just discussing in general. It's not about your case. Yeah. We're not talking about your case. We're just talking in general. We're having a discussion as to when DUI is an issue and when it's not. But in your case, I wouldn't worry about it. I don't think it is an issue.
Sure. And one more question. It's like a lot of people are applying for EB2 to EB3 downgrade and filing it. But what is the exact process will happen after we file? We receive the notice receipts from USCIS, and after that, do we get any appointment letter for biometrics? And when will be the final interview? Is when the final action dates is met, or it can be happen anytime?
Only when the final action date is met, you will have an interview. Before that, you will have your I-140 will get processed, and then your biometrics will be processed. And then the final approval or interview, if it happens, will be once the final your date becomes current.
Oh, okay. Yeah, thank you, Prashant. That is all my questions.
Okay, thanks for calling. We have another caller, Nag, number ending 3417.
Hi, this is Sanjeev here. Hi, Prashanti.
Hi.
Hi. I got my I-140 approved in 2015, and in EB2 category. And obviously with this delays, obviously we didn't get a chance to file I-485 till now. And now with whatever happened in recent years, I planned something and just wanted to know your opinion on it if there is some issue with this plan. So what I thought is, I have Canada PR as well. So I thought I'll go to Canada for the same employer that I have right now in US. They have their organization in Canada as well. I go to Canada, work there for 1 year, come back to US, and then file my green card under EB1 category. I am at a manager position, so that criteria is met, obviously. So just wanted to know your opinion on it. That do you see any point that I'm missing over here, or any concerns or anything?
It's a good plan as long as everything gets approved and you qualify for the position. Simply being a manager doesn't mean you automatically qualify. You have to know that. And every case is really, they have no uniformity in their processing. So they might approve one case and deny the other case. So that's the risk that everyone takes whenever you file any case with USCIS. So other than that risk, if you meet the basic criteria, your plan is a good one. You can file directly for an EB1, and file the I-140, and then based on priority dates, file your 485. You also, since you're outside the country for a year, you also get an additional 6 years on your H1 if you want to come in on a H1. But then, of course, you're cap subject. So you'll have to come during the cap season.
But I have the I-140 approved, so can't I just come anytime?
I-140 doesn't give you status, right? I-140, on what basis will you come in? You have to come in on some basis. Either you have to file an L1, or you have to come into the country after you get the green card, which is in EB1A situation. You have to then file the I-140 and file a non-immigrant visa and come in on a green card itself. Or you have to find a non-immigrant category to come in. You cannot file just an I-140. You need to have you cannot get work authorization based only on an I-140. You need to file adjustment of status if you're here, or you have to file for an immigrant visa if you're outside the country. Get an approval on the immigrant visa, then come in, and then process the green card here, and then you can start working. Magically, you cannot start working on an I-140 approval. So that's why I'm saying in the interim, you might want to be on a H1 or an L1, and I was just giving you that additional information.
Right. Yeah, exactly. That is what I meant to say, that since my I-140 is approved and I'm in Canada, my employer in US, they can file for my H1. I can come on H1 and it will be cap exempt because of my I-140 approved.
Correct.
Right? And then I can come on to H1 in US.
We're both saying the same thing.
Yeah, right. So in the same terms and on the same criteria, with whatever is going on with the the country limit being removed, I just wanted to get your opinion on if this country thing gets removed, country limit gets removed, since my EB2 priority date is 2015. Would it even be a good idea to, go out of US, spend 1 year, come back to US, and maybe if country limit is gone, maybe my priority date...
Well, it's all speculation now. We don't know what's going to happen. So nobody has a magic wand. Nobody knows whether this bill will be passed or not. We can only hope that, it will be passed with some changes. Everybody wants some changes to the bill. So everybody has their opinion on that there's good things and bad things. So whatever it is, we don't have a magic ball to know whether the bill will be passed or not. If it is passed, even if it's passed, if it's based on the Senate bill, and we haven't had a chance to go through the what the Senate bill says, but if it's based on the Senate bill, it might take some time because they have a 10-year moratorium where still certain number of visa numbers are reserved for rest of the world. So it might take another 5 years, 7 years, 10 years for all the backlog to be cleared. And if you're 2015, there are a lot of people who are obviously 2011, 2012, so it's hard to say. Depends on which bill will be passed. If it's a Senate bill, then there's only a 3-year moratorium whereby, the rest of the world is given a reservation. In this Senate bill is a 9-year period whereby, the rest of the world continues to get preference. So it's obviously going to take longer than for people who have newer priority dates.
Okay, so my plan is, I consider my plan is better than,
Yeah, because you at least
add-
have something in hand. If the bill gets passed and if you see the visa numbers have moved, you can always come back. What's stopping you?
Just to add to that, you might not get green card for a few years, but you'd get an EAD after a year. After a year, you can apply for an EAD. But then, if the bill is passed. So just wait for 2 or 3 weeks if you want to. And in 2 or 3
Right,
weeks,
because it has to be passed by January 5th, right, Ranjit? So if it doesn't get passed by January 5th, you know that it's not going to happen. It might, and we don't know then again when it'll happen. So that's a good.
So just wait until then. Yeah, if it's passed,
So
you'll be able to apply EAD after a year.
Yes,
of the
correct.
bill.
Yes, after 2 years. 2 years. If it goes
EAD
based on the
after
Senate.
1 year.
I will.
EAD after 1 year, but GC quota after 2 years.
That's not what the Senate bill says, Ranjit. But we will discuss that.
So January 5th is the date I should wait for. Right. Okay. All right. One question which is not at all related to green card, but recently the H4 and H4 EAD premium processing, I don't know what legally what you call it, but some bill came out, right, which was saying, okay, we are gonna process it, or it will be available. Any news or any updates on when that will be available?
The what bill? H4 EAD.
H4 premium and H4 EAD premium processing.
No, that was so nothing has come out yet. The Congress did. They basically increased the fee for premium processing, and they have allowed the USCIS to decide when H4 EAD premium processing can start. But USCIS obviously is not in a rush to do that. So maybe they will do it once a new administration comes in. But as of now, that doesn't seem to be a priority. It seems to be more restrictionist. So all their attentions are going towards putting in more and more restrictions. So I don't know if giving any benefits is a priority at this point. But we will know with the new administration for sure to what the premium processing, to what extent it is extended. But the House and Senate have passed the bill saying that it should be, but I think they've given the leeway to the USCIS to decide when and how it is to be implemented. So we have to wait and see.
Right. Okay, and one last question.
Okay, we have a lot of callers waiting.
Yes,
so,
I think we should take.
Yeah, we should move to the next call.
Move on. Just one question per caller, maybe, so that everybody will get a chance.
Yeah, the next caller, number ending 2742. Please ask your question. Please limit a question to only one, so there are a lot of callers in line.
Hey, hi. My name is Kushagra Mittal. I have a question for you. Suppose, in US, somebody has got the project which is over, okay, and the company has filed an extension for the project. In that case, will it be possible to work for a new project and get the RFE response from the old project, or do we have to withdraw the old extension? How should it work?
Well, the more important than project is work location. So if you're working from home right now, then the employer will has to show that you have work, that they have work for you. And to show that they have work for you, usually they'll give a SOW or something like that, right? So if as long as the work location doesn't change, and as long as they show at the time of filing the RFE that yes, we were supposed to put him on project A is over, but we have a new project for him, which is project B, and the project A was genuine, and here are the POs for project A to show that he worked on it. And this is the POs for project B showing that it is a genuine project. The work location has not changed because he's working remotely. They should still approve the case. It cannot be speculative. So as of the date of filing, as long as it was not speculative, the employment, it's fine if the project got over. as long as there is a new project.
Okay. So that answers my question. And only one thing is, like, in that case, if suppose the employer B, suppose in that case, if the project itself do not have the end client letter, then how they will publish it to the UCIS? Is it important to publish the end client letter? Because the project is already over for the old client.
Yeah, that doesn't matter. Even if there's no end client, there are other ways of showing that the project existed when it did.
Okay.
Okay.
Sounds
Okay.
good.
Thank you.
Thank you.
Bye.
Okay, we'll take the next caller, Raghu, number ending 1934. Number ending 1934.
Hi, Prashanti. Hello, all.
Hello.
Yeah, please go.
I have only one. Can you hear me?
Yes, go ahead.
Yeah, thank you, ma'am. So my question is, my full name is four-word letter. Like, my full name is Venkata Raghukiran Alamuri. So on the H1 797C receipt form, so what happened is my first name and the last name were fine. They are pretty good. On the middle name, one of the middle name is Kiran. So instead of Kiran, it was printed as Kira. So the single letter N is missing. So will that affect down the line for me, or do I need to raise a request to USCIS for the name change?
It looks like it's been abridged because there's no space. So as long as the original H1B form was filled out correctly, I don't think there is an issue with that one letter being missing. I think it's most probably I have a feeling it was abridged because of lack of space. And they do that sometimes.
Yeah, I understand that one, ma'am. Even I've thought the same. Like, even on my SSN, what happened is earlier when I applied for initially, so they have given the same answer. So as the name is very lengthy, the first and last name they have taken it, and on the middle name they just considered as the first letter of each middle name. So just they taken two letters. But when I compared, one of my other friends is having more lengthier name than me. He has complete name on his the 797C document, but whereas mine.
Go ahead and contact USCIS and ask them to change it. What can I tell you? I'm telling you something, but you're not listening.
No, my question is just, will it affect me in any way, or do I need to contact?
I'm telling you it will not, but if you are still concerned about it, there is no harm in asking your employer to contact USCIS to have it changed. That has to be changed before it gets approved. So make sure you change it now that you have gotten the receipt. Okay?
Okay. Yeah.
Thank you.
Okay, ma'am. Yeah, thank you.
Okay, the next caller, number ending 1940. Number ending 1940.
Hi. Hi, this is Kumar here. Prashanti, first of all, thanks to you and for your patience for answering these questions.
No problem.
I had my labor done with the employer A sometime in early 2011, and now it's opened up for me. So I filed for 485 adjustment of status. But however, since it is almost 10 years, I have moved on, and probably I'm with employer B now. So when I started with employer A, but however, employer A had this position open, and he was willing to take me back, so we could file 485. So the question here is: so do I need to go back to this employer once I get the EAD approved, or once I get the green card? What is the process I need to follow?
I suggest you go back once you get the EAD approved.
Okay, yeah, that would be better, right? Rather than waiting till green card.
There won't be any issues on getting your green card approved then. Otherwise, there might be a question mark.
Oh, okay, got it. Fine, thank you so much. And quick question is, my son is already aged out. In case this new bill gets into law, so will he be eligible to file for his green card later?
Well, I don't know if they'll make it retroactive. It's only moving forward. So if he's already aged out, he might be out of luck.
Yeah, there are a couple of lawsuits for that to make it retroactive. If something is of that lawsuit is passed, then he'll be protected. Otherwise, no. This S386 or HR 1044 is only effective in current situations. It doesn't go retroactive.
Great.
So,
Great. Thanks
thank
so
you for your call. Bye.
Thanks.
So, I was thinking, Ranjit, that we'll just go through some elements quickly, at least 5 minutes, and then the callers will wait. And after that, we'll continue taking callers, because we did say that for people who are listening, we also have to give them what we promised.
Yeah, 1 second. I have one caller. I already picked it up. Let's take this one and just.
Okay.
The number ending 0988. Please go ahead. Please be quick and one question only.
Yeah, sure. Hi, Prashanti. This is Srinivas here. Hi. So actually, I have only one question. That I'm going to file Y129, and my employer is asking me, this is like amendment, so HMD amendment, they're asking me to to fill the benefits, public benefits below, like that, and there is kind of 2 options he's asking me, not receive of the below listed benefit, and second is not certified to receive any of the listed public benefits. So which option I need to select?
Select both.
Select either A or B?
No.
Both,
so if you're not eligible for any future benefit, which means a benefit is there, but it's going to start in the future, they want to know about it. That's the question. That's what they're asking.
Right?
I don't know whether it's A or B. I don't have the form in front of me, but my answer to you is, I'm telling you what the meaning of those 2 lines are. One is they're asking if you have received a public benefit already or are receiving it now. The second question is, have you been certified to receive it in the future? Okay, so you have to answer accordingly. So if everything is no, you have to answer no.
It's not. But it's not mentioned the future. They just mentioned not received, not certified to receive any of the listed public benefits. Means I checked on the internet. They mention to certified means you need to give some process, 4 to 5 weeks it will take, and get some.
Right, you're not. So you would know. You would know that you're not certified, right? You know that, right?
Yes, right.
You're obviously not. You're not certified. You did not apply for any certification, correct?
Right.
Okay, then it's no.
Okay.
Okay.
So I need to say A and B both, right?
Why don't you send me an email after this call? I cannot answer how to fill out a form during this call. Okay, I can only answer, legal questions that you ask me. I don't have the form in front of me. I cannot answer that question.
Okay.
Okay, yeah. We can continue with our discussion on the bill, Prashanti.
Do we have other callers?
We have 2, but we'll take after
Okay, let's discuss for 5-10 minutes, and then we can take those other 2 calls. Okay, thank you, Ranjit. So so one thing about the main thing with reference to the Senate bill is that they have removed the 7% per country cap, which is the main thing. And the second provision is it's a 11-year phase-out period, unlike the House bill. So I'm just pointing out the differences, which is a 3-year phase-out period. So the first year, which means that there's a reservation given for rest of the world for 11 years. So in the first year, they'll be given 30%, second year 25%, third year 20%, then 15%, 10%, and then from years 7 through 9, it's 5%. So, and also in this reservation, also in this percentage, no more than 25% can be used by one single country. So they're making sure no one country dominates even in that rest of the world. And in the same way, no more than 85% of the unreserved green cards can go to a single country. So India and China can't get more than 85% at any given period of time. Also, they said in addition, a minimum of 5.75% of all EB2 or EB3 cards will go to rest of the world. Again, they've given an additional 5.75% for spouses and minor children. So you have to add it all up. It's not 100%. And there's a 11-year phase-out period when compared to the 3 years given in the House bill. There's a guarantee for nurses and physical therapists they've been given 11% quota in the green card. So this is because these are considered to be shortage areas by the Labor Department and have been for many years now. This is not a good. This next one, which says basically H1s and H4s can't get more than 70% of the green card numbers. So they've put a cutoff of 70% for all H1 and H4 visa holders during the first 9 years, and thereafter only 50%. So this is really bad because they're reintroducing the quota system again. Because as we know, again, this is not in the House bill. So as we know, 90% of the EB2 and EB3s are on H1. There might be a small percentage on L1, maybe some on EB5, but 90% are on H1. So by putting a 70% moratorium on H1s, they're again reintroducing this kind of quota system. Not a good thing. Of course, people will argue that something is better than nothing, but it's not ideal. But I guess it's a work in progress, and let's see what finally happens. As of now, the next 9 years actually, this clause will not really affect much because already there's a 85% limit on all EB2, EB3s. So this really net will not have any effect, at least for the next 9 years. But after that, since it's going down to 50%, it might have an effect. But it's good to know that it's in there. The bill is mostly about employment-based, but there is some family-based relief also. And though they have not removed the country quotas for family-based, they have increased it from 7% to 15%. So that's a good thing. And one of the amendments. So the previous amendment about 70% of only 70% going to H1s. That's the Rick Scott's amendment. And the other one is the Chinese affiliated with the Chinese Communist Party. They're saying that they should not be allowed to adjust status and they should only be allowed to do consular processing, which I don't really understand what is the thinking behind that, because if they can't adjust, then they'll just go for consular processing. It's the same thing. Do they intend to be stricter when it comes to consular processing and maybe deny them there? Because it's a very broad term, affiliated to Chinese Communist Party. Most people in China are affiliated because it benefits them if they're affiliated. It looks good on their resume if they say they're affiliated in some way. So because of that benefit, most people are affiliated, not because they ideologically, they're affiliated with ideology. So I think that is, again, discriminatory for Chinese nationals. And then we have some really, really, really good clauses which are in the House bill as well and in the Senate bill. So other than removing the per country caps, which is the main thing, it's also the allowing you early filing. So basically what's going to happen is if 2 years after an I-140 has been filed, and if you still don't, your visa number is still not available, then you can act as if it is available. It's like a dates for filing. So your final action date won't be available, but it'll be as if dates for filing is available. So you can file a 485 and you can get an EAD, but of course you won't get the final green card until your date is actually available. So this is very interesting because much better than what it is at present. At present also we have noticed in the October Visa Bulletin, there was a window open up for dates for filing. It's similar to that. But in this, you get a 3-year EAD, not a 1-year EAD. You don't have to keep renewing it. It's a 3-year EAD, which is great. So it's like filing a 3-year extension every year without, all those restrictions that are due on a H1. But there is some also other things that have been mentioned that are not there, were not there earlier. You have to show that the wage is commensurate with, when you're filing this, when you're filing the EAD, you have to show that the wage is commensurate with people either in your employment, in your job, in your industry, in your area, or your employer is paying similar wages to other people. So you have to show commensurate wages, which was never a requirement, which is not a requirement now. So they want to make sure that no one is underpaid or paid less, and that they're paid equal to everyone else. And also there will be a $2,000 fee So every time you want to change employers, you can do that after 180 days, same thing as the present rule, but there will be a fee involved for the portability, and they're going to be charging 2,000, which I think is fair. Most people will be willing to pay that fee anyway. So then there are a lot of restrictions on the H1, and I am not going to go through each one, but they're very significant, and it can change the H1, the way H1s are done completely. And this will be a problem even for those people who are waiting in the green card lines. Because remember, they can't file for they have to move to a, most probably, unless they're on an F1 and they get STEM OPT for 3 years, if they're coming in on a H1 or they're already on a H1, they'll have to wait for a period of 2 years, file the I-140, and during that time, they have to be on a H1. So if you make the H1 so restrictive that it is almost impossible to get it, then what is the purpose of giving them the green card? Because they have no status for the 2 years. So a restriction on H1s is a restriction for everyone, hurts everyone. It hurts all Indian nationals, not just people who, waiting for green cards or, everybody at some point goes through the H1. It's a process. You go through F1, H1, green card. So you don't cut off your left hand to fix the right hand, right? So it has to be a bill which is balanced in all aspects with reference to non-immigrant visas as well as immigrant visas. So that is my opinion. So here they're saying that you have to do a 30-day advertisement process before you can even file a H1, which means that no client is going to wait for 30 days, right, for you to join them. So it's like filing a green card. So that requirement has been included. There's some requirements which are very reasonable, which I have no problem about, which is basically, ban advertising saying that only H1s should respond to this advertisement. That that is not allowed. That's not allowed even presently, but they've put it in writing. Bans recruiting primarily H1. So which means if you have a person who's qualified, you cannot simply hire him because he's the best person for the job. You have to find a US citizen first. And if you don't find the US citizen, only then you can hire. That is very onerous for a non-immigrant petition. Do that for the green card. But for a non-immigrant temporary petition to have the same requirements is pretty much like killing the H1. So, that's one of the requirement. The other one, which is, this could affect is big companies that if you have 50 employees and more than 50% of them are
Prashanti Garu, just
yes.
Sorry to interrupt you. I think we are towards the end of the show. And
I'm just going to finish very quickly that if they're more than 50% are H1B dependent, then pretty much you cannot file, those companies cannot file H1s. So they have to merge most probably with other companies that have more US citizens so that they're not H1B dependent. So that's a big change also, which hopefully, the House version or the final version won't have. And the rest are all with reference to DL regulation, etc., and we can skip those. So we've covered most of them.
Yeah, we can discuss in probably in detail next week, hopefully some progress. Again, thanks for all the calls and watching the show. It was a great session with interesting topics and questions. Please call in every Wednesday at 5:30 p.m. EST to watch the Immigration Talk Show. Again, it's every Wednesday, 5:30 p.m. EST and Sakshi TV. This is Ranjit signing off. Thanks.